Buddy, please do call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Michael Bandler versus Bank of New York Mellon Trust, case number 23 AP 189. Appellant Michael Bandler is self-represented and is appearing by phone. Representing the appellee, Bank of New York Mellon Trust, is attorney Elizabeth Lacombe.
Okay, thank you. Mr. Bandler, can you hear me, sir?
I can, thank you.
All right, and I can hear you. We can hear you. So you understand you have 5 minutes. We'll try to give you an alert when you have about a minute remaining, or you're entitled certainly to reserve time as well. So go ahead, please.
Okay. Well, the underlying matters situation has changed. Therefore, plaintiff asks the court to dismiss this action without prejudice. Plaintiff has received notice that the Bank of New York Mellon Trust has sold its interest in the underlying mortgage and no longer has standing or reason to continue its foreclosure action. There are multiple motions to dismiss the Rutland foreclosure action now pending, which the defendant has not opposed. Therefore, plaintiff asks this suit be dismissed without prejudice, which Bank of New York Mellon has no reason to oppose.
All right, sir. All right, you're welcome to reserve the remainder of your time, and we'll turn to the counsel for the appellee. Please identify yourself and your client, and then proceed.
Yes, good morning, Your Honors. Attorney Elizabeth Lacombe on behalf of the defendant appellee, Bank of New York Mellon Trust.
Thank you.
May it please the court, I'm here today primarily to ask the court to affirm the trial court's decision to dismiss Mr. Bandler's underlying lawsuit against Bank of New York Mellon with prejudice for the following reasons. First, several of the counts of Mr. Bandler's complaint represent claims that Mr. Bandler does not have standing to assert. Specifically, those claims, as laid out in our brief, are related to contractual claims or claims belonging to a third party, an individual named Deborah Tyler. And those claims are the subject of a related action, a foreclosure action brought by Bank of New York Mellon against Ms. Tyler.
Ms. Lacombe, so this case that Mr. Bandler brought is not a foreclosure case itself. This is a case involving basically a declaration of rights as to what rights Mr. Bandler has in an action against your client. Is that correct?
That's correct, Your Honor.
But as to having being a signatory on a note or a mortgage or any type of any type of interest in the property itself, there is no relationship between Bank of New York Mellon and Mr. Bandler?
So there's no contractual relationship, Your Honor, but Mr. Bandler did receive a nominal, I believe it's a 1% interest in the subject property that is encumbered by Bank of New York Mellon's mortgage long after the foreclosure action had been initiated by Bank of New York against Ms. Tyler. Under the statute 12 VSA 4932B, because Mr. Bandler's interest was acquired and recorded, both acquired and recorded long after the complaint was recorded with the Registry of Deeds, Mr. Bandler is not entitled to be made a party to the foreclosure lawsuit. And that is really the crux of his lawsuit against Bank of New York Mellon. He here is attempting to assert claims related to the contractual relationship between Ms. Tyler and Bank of New York Mellon, which he does not have standing to do because he's not party to that contract. And he's attempting to collaterally attack the trial court's decision to not admit him as a party in the foreclosure action where there's no requirement to do so.
But so with his 1% interest, his having some interest in the title of the property, even after the fact of the foreclosure, would his interest need to be foreclosed in order for the property to be foreclosed upon and up for sale?
No, Your Honor, he would not need to be made a party to the foreclosure action as a matter of law under that statute. Again, 12 VSA 4932B. His interest would be extinguished as a matter of law through the foreclosure. And that is because the foreclosure complaint, was recorded with the Registry of Deeds prior to his acquiring and recording his interest on the Registry of Deeds. So he's not a necessary party to that lawsuit.
What about his claim that you sold the mortgage? Does that make any difference here?
So it doesn't, Your Honor, and I appreciate you bringing that up. Certainly, if Mr. Bandler seeks to dismiss his appeal, and he's certainly entitled to do that, but it's not without prejudice. As a preliminary matter, the trial court did enter a dismissal with prejudice and with good right and reason because of the reasons that we've set forth in our brief. He has no standing to bring his claims. He's making a collateral attack as against the trial court in the foreclosure matter. But moreover, simply because the Bank of New York Mellon's interest was sold to a new party does not render it without standing. Under Vermont Rules of Civil Procedure 25C, even when there's a transfer of interest, a lawsuit may be continued by or against the original party. And so there's no obligation to dismiss or even to substitute in the new owner of the loan. And I would suggest that that remains here as well with respect to the appeal. Moreover, this is consistent with the concept of res judicata. The new owner of the loan stands in privity with Bank of New York Mellon. And so the dismissal of the underlying lawsuit here with prejudice is equally applicable to the new owner of the loan as it is to Bank of New York Mellon. So to the extent that the court decides to dismiss the appeal, it should be with prejudice. And similarly, any further lawsuit that Mr. Bandler might seek to bring against the new owner would be barred. Thank you.
Okay. All right. How much time does the appellant have, please?
Appellant has 4 minutes and 8 seconds remaining.
Mr. Bandler, are you still there, I hope?
I am.
Oh, good, good. You hear that? You've got over 4 minutes, and you've heard what counsel for the bank has said. Please go ahead.
It's ironic that the underlying trial court issue, or one of them, was the issue of standing. I would submit that Bank of New York Mellon does not have standing to even participate in this hearing. They no longer have any skin in the game, so to speak. Whether the court reverses, dismisses, affirms, makes absolutely no difference to them. There is no harm or gain to them by what this court does. Therefore, they do not meet the three-pronged standing requirement. I'll say quickly again that it's my primary argument that this suit and appeal should be dismissed without prejudice. Why the Bank of New York Mellon Trust should oppose this, since they have nothing to gain or lose other than, well, let me leave out the other than. There's no reason for them to oppose what I've asked for. As to the merits, if there was to be an adjudication on the merits on the appeal, in the underlying trial court, the defendants did not file an answer. Therefore, the court and the trial court are required to accept all the factual allegations set forth in the complaint as true in plaintiff's complaint. The issue raised in this appeal involved the application of law to undisputed facts. Therefore, this appeal is not subject to a deferential standard of review, making the standard of review de novo. As to the issue as to whether I had standing or not, it is long settled that there is a three-part test that should be applied. I have set forth a declaration of rights, status, and other legal relations of parties to an actual judiciable controversy. The defendant's foreclosure of the property would result in my losing my interest in the underlying real estate, Whether I was a party to the mortgage or not makes no difference. What does make a difference is at this time, would I be injured? I seek a declaratory judgment, which was well within the trial court's ability to do and would prevent my loss. As to collateral attack, defendant mistakenly argued before the trial court that in considering a collateral attack, that it did not accept the fact there was no judgment, final or even interlocutory, in the Rutland suit to be attacked. Simply as it is to say, there cannot be a collateral attack and then a judgment that never was. A collateral attack is not on a lawsuit.
Mr. Bandler, you have 1 minute left, please.
Yep, I'm right at the end. Simple as that. A collateral attack is not on a lawsuit, but on an order. I have attempted to appeal my denial of admission to the Rutland suit. This court, a different panel, since it was interlocutory, deferred it for a final judgment. So in that sense, it's not a collateral attack. This is not trying to avoid an appeal of the Rutland decision. I tried to appeal it, but it was deferred for a later time. And secondly, that there was no order that I'm attempting to attack. I'm merely trying to, there was no judgment that I'm trying to attack. I'm merely trying to contest the fact that I am a party in interest. That I'm a party in interest and I should be included in the Rutland suit. That's it. Thank you.